Good afternoon, everyone, and welcome to the Government Records Council's April 30th, 2024 meeting. I'm Executive Director Frank Caruso. We're in the process of admitting everyone into the meeting and placing everyone on mute. We will begin just as soon as that process is concluded, which should take a couple of seconds here. Appreciate everyone's attendance today, and we'll get started here momentarily. All right. Chairwoman Tobacco, when you're ready.
All right. Good afternoon, everyone. Welcome to the April 30th, 2024 Government Records Council meeting. Please rise for the pledge. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This meeting was called pursuant to the provisions of the Open Public Meeting Act. Notices of this meeting, inclusive of call-in information, were faxed to the Newark Star Ledger, Trenton Times, Courier Post of Cherry Hill, and the Secretary of State on April 25th, 2024. Members of the public attending the meeting via telephone have been placed on mute by the presenter. At the time that the council arrives at its public comment portion of the meeting, members will be taken off mute and given an opportunity to provide public comment. Please note that the council will strictly adhere to the 5-minute time limit. Additionally, copies of today's meeting agenda can be accessed on the GRC's website at https://www.state.nj.us/grc/meetings/minutes. Proper notice having been given, the secretary is directed to include this statement in the minutes of the meeting. All right, roll call, please.
Robin Tabaki.
Present.
Michael Hahn.
Present.
Don Alexi.
Present.
Hillary Tardy.
Present.
All right. Mr. Caruso, would you like to give the executive director's report?
Let's get off mute there. There we go. Good afternoon to all of our council members, staff members, and of course our attendees at today's meeting. As always, we'll go through our current statistics as of today. Since OPRA's inception in July of 2002, the GRC has received 7,057 denial of access complaints, which averages about 324 annual complaints per 21 3/4 track program years. Just so that the attendees know, program year is denoted by fiscal year. So far in the current program year, which is fiscal year 2024, the GRC has received 272 denial of access complaints. Again, that's 272 denial of access complaints for FY24. Of our 7,057 complaints, 591 remain open and active, or 8.4% of all complaints filed with the GRC. As a breakdown, 10 complaints are currently on appeal, 37 complaints are currently in mediation, 3 complaints are proposed for the Office of Administrative Law, 27 complaints await adjudication at the Office of Administrative Law, 48 complaints are tentatively scheduled for adjudication at upcoming GRC meeting, including today. 466 complaints remain work in progress. As for our inquiries, since program year 2004, the GRC has received and responded to 38,920 total inquiries, which is averaging about 1,876 annual inquiries for 20 3/4 track program years. Again, noting that we did not track inquiries in the first year of the agency's history. So far in the current program year, fiscal year 2024, the GRC has received 1,430 inquiries, which averages about 6.9 inquiries per workday. In terms of outreaches, we do have an outreach coming up on May 6th, which will be held virtually for the Division of Elections. And that is my report.
Robin, you're on mute.
Sorry. Apologies. We're going into closed session now. Whereas NJSA 10:4-12 permits a public body to go into closed session during a public meeting. And whereas the Government Records Council has deemed it necessary to go into closed session to discuss certain matters which are exempt from public discussion under the Open Public Meetings Act. And whereas the regular meeting of the council will reconvene at the conclusion of the closed meeting. Now therefore be it resolved that the council will convene in closed session pursuant to NJSA 10:4-12B7 to discuss Stephen Schnitzer Esquire on behalf of Vito's Trattoria, Inc., v. New Jersey Transit 2016-140 for an in-camera review, NJAC 5:105-2.8G. Mr. Ricciardi is recused from that. And Joseph Holdsley v. City of Clifton, Passaic 2021-113 for an in-camera review, NJAC 5:105-2.8G. And Mr. Ricciardi is also recused from that. Be it further resolved that the council will disclose to the public the matters discussed or determined in closed session as soon as possible after final decisions are issued in the above cases. Could I have a motion to go into closed session, please?
Second.
Robert Betsabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Secretary Tardy.
Recused, and I will not be participating in closed session.
For all of our attendees here, including Mr. Ricciardi, who is recused from the closed session, remain on the line here. We're going to go into a different channel in order to conduct our closed session. So stay here. You don't have to hang up. We'll be back to this. I anticipate somewhere in the neighborhood of 15 to 20 minutes, so it could be a lot shorter, depending on how the reviews go. But stay here. I stress that everyone can stay here. There is no need to hang up and call back in. We will return to this line as soon as we're done with our in-camera. So appreciate everyone's patience. We'll be back as soon as possible. We could have all of our council members place themselves on mute and turn their camera off. That would be very helpful. Thank you. All right, good afternoon, everyone. We are coming back in now to restart the public session. As soon as everybody is back on this side and able to vote to restart the meeting, and we'll get started. Mr. Ricciardi, you can take yourself off mute there too, since we're back here.
I'm here, Frank.
All right, are we ready?
We are waiting for DAG Gleason, it looks like, and Mr. Hahn.
I'm here. This is Stephen.
Oh, there you are. So it looks like we're just waiting for Mr. Hahn. He's currently busy. I hope. Oh, there he goes. Yeah,
I had
we were wondering.
I didn't get my normal room so I left my computer to go to a private area for the in-camera review and had to walk back.
There you go. We are back. Okay, now we are situated and ready to go.
All right, could I have a motion to return to open session?
I'll move.
Second.
Robin Brett-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ricciardi.
Yes.
All right, we move into approval of the meeting minutes. Is there any discussion on the March 26, 2024 open session meeting minutes?
Madam Chairwoman, just one question on the GRC staff in attendance. Wasn't John Stewart also in attendance at that meeting?
I will defer to Mr. Crusoe as I was not in attendance at that meeting. And I'm
Open
abstaining.
session, Mr. Alexi, or the closed session?
The open session. I didn't see John Stewart's name mentioned. I thought I'd recall that he was in attendance.
Okay, so we'll have to go ahead and make that change. That might have been a carryover from last month.
Are there any other comments?
I think that'll be
Okay.
an edit.
Yeah, I know. All right, with that edit, could I have a motion to approve, please?
I'll move.
Second.
Robin Brett-Tabaki,
I'm abstaining.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ricciardi.
Yes.
Thank you. Is there any discussion on the March 26, 2024 closed session meeting minutes? All right, hearing none, could I have a motion to approve, please?
I'll move.
Second.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ricciardi.
Yes.
And I am abstaining. Okay. Now we move into new business cases scheduled for consent agenda administrative complaint disposition adjudication. An administrative complaint disposition means a decision by the council as to whether to accept or reject the executive director's recommendation of dismissal based on jurisdictional, procedural, or other defects of the complaint. The executive director's recommended reason for the administrative disposition is under each complaint below. There are no administrative disposition adjudications with recusals, but there are 8 with no recusals. And I will ask Mr. Caruso to read those, please.
Number 1, Rotimi Ovo Esquire, OBO, African American Data and Research Institute, v. Cherry Hill Police Department, Camden, 2022-15. All records provided in a timely manner. Number 2, Rotimi Ovo Esquire, OBO, African American Data and Research Institute versus City of Linwood Police Department, Atlantic, 2022-21. All records responsive provided in a timely manner. 3, Rotimi Ovo Esquire, OBO, African American Data and Research Institute, v. Northfield Police Department, Atlantic, 2022-24. All records responsive provided in a timely manner. Item number 4, Bertimio Esquire, OBO, African American Data and Research Institute, the Belmar Police Department, Belmar Borough Police Department, Monmouth, 2022-63. All records responsive provided in a timely manner. Number 5, Akash Dalal, the Bergen County Prosecutor's Office, 2024-65. Motion to file within time denied. Laura M. Campanella, number 6, Laura M. Campanella, the Town of Secaucus, Hudson, 2024-77. All records responsive provided in a timely manner. Number 7, Edward Thomas Clifford III, the Administrative Office of the Courts, 2024-79, not within the council's jurisdiction. Number 8, Laura M. Campanella, the Township of Secaucus, Hudson, 2024-86. No records responsive to the request exist.
Thank you very much. Could I have a motion to accept all those aforementioned cases, please?
I'll move.
Second.
Reverend Brett Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rui Hurtado.
Yes.
All right, we move into administrative disposition, uncontested voluntary withdrawals by complainant where there is no adjudication of the council required. However, I will again ask Mr. Caruso to read through those.
Number 1, Brian Gurney, the Borough of Pennsgrove, Salem, 2022-56. Complaint voluntarily withdrawn. Number 2, Rotimi Owo Esquire, on behalf of African American Data and Research Institute, the Bayonne Police Department, Hudson, 2022-303. Complaint voluntarily withdrawn. Number 3, Sean G. Hopkins, the Hunterdon County Board of Taxation, 2023-95. Complaint voluntarily withdrawn. Number 4, Kara K. Parham, the Montville Township Board of Education, Morris, 2024-26. Complaint voluntarily withdrawn. Number 5 and 6 are consolidated. Diane Loudenbach, the Kingwood Township, Hunterdon, 2024-75 and 76. Complaint voluntarily withdrawn. Number 7, Kevin Kearns, the Borough of Seabright Police Department, Monmouth, 2024-87. Complaint voluntarily withdrawn. Item number 8, Scott Betsy, the City of Newark, Essex, 2024-88. Complaint voluntarily withdrawn.
Thank you. We now move into administrative orders. New business cases scheduled for the consent agenda for administrative orders. An administrative order means an order issued by the council requiring the records custodian or the complainant to perform a specific action in furtherance of the adjudication of a pending denial of access complaint or taking other actions deemed appropriate to adjudicate a complaint in an expedited manner. The executive director's recommended reason for the administrative order is under each complaint below. There are no administrative orders with recusals and no administrative orders without recusals. So we move into individual cases or cases scheduled for individual complaint adjudication. All right, we move into individual complaint adjudications with recusals. Stephen Schnitzer Esquire on behalf of Vito's Trattoria Inc. v. NJ Transit 2016-140. Mr. Ritardi is recused.
Note that he's been, Mr. Ritardi is placed on mute so that he cannot participate in this particular set of cases 1 through 5 under the recusal list, as he is recused from them. Okay, so for item number 1, the proposed findings are: the current custodian complied with the council's November 8th, 2023 interim order. The current custodian shall comply with the council's in-camera examination findings. The knowing, willful, and prevailing party analyses are deferred.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second.
Reverend Brett Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Joseph Holtzley v. City of Clifton, Passaic 2021-113.
Custodian did not comply with the council's January 30th, 2024 interim order. The in-camera examination reveals that the custodian lawfully denied access to the requested Palmer report under the interagency or intra-agency advisory, consultative, or deliberative material exemption, NJSA 47:1A-1.1.
Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. City of Bayonne, Hudson, 2021-213.
Complaint should be dismissed because the complainant withdrew it in writing via email on April 11th, 2024. No further adjudication is required.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. City of Bayonne, Hudson, 2021-214.
This complaint should be dismissed because the complainant withdrew it in writing via email on April 11th, 2024. No further adjudication is required.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Jason Richwood v. City Village of South Orange, Essex, 2022-435.
Custodian's failure to respond to the June 17, 2022 OPA request within the extended deadline resulted in a deemed denial of access, NJSA 47:1A-5G and NJSA 47:1A-5I, as well as Cone v. Township of Livingston Library, Essex, GRC complaint number 2007-124, March of 2008. The custodian's failure to timely respond to the June 20th, 2022 OPA request also resulted in a deemed denial of access. However, the GRC declines to order any further action because the custodian disclosed the responsive records on July 14, 2022 and August 22nd, 2022, respectively.
Thank you. Is there any discussion? Hearing none, motion, please.
I'll move.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
All right, we move into individual complaint adjudications without recusals. Mr. Ritardi can unmute, please. Thank you. Rotimi Owo Esquire on behalf of Grace Woko v. Mount Holly Township Police Department, Burlington, 2021-71.
Custodian did not unlawfully deny access to the responsive personnel information, NJSA 47:1A-10, OO XREL African American Data and Research Institute, the Maple Shade Police Department, 2024, NJ Super Unpub Lexus 445 Active 2024. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Very retarded.
Yes.
Mary Beth Maida v. Borough of Red Bank, Monmouth, 2021-229.
Current custodian complied with conclusion numbers 1 and 2 of the March 26, 2024 interim order, but failed to comply with conclusion number 3. Council's order is enforceable in Superior Court. NJ Court Rules R 4:67-6, NJAC 5:105-2.9C. The current custodian's actions may have been knowing and willful. Thus, this complaint should be referred to the Office of Administrative Law for knowing and willful hearing.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second,
Reverend Betty Balkin,
Yes.
Michael Hahn,
Yes.
John Alexi.
yes.
Very retarded.
Yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Runnymede Police Department, Camden, 2022-13.
Custodian's response was insufficient because he failed to address each OPA request item individually. NJSA 47:1A-5G, PAFB Willingboro Board of Education, Burlington, GRC complaint number 2007-272, May of 2008. Custodian did not unlawfully deny access to the portion of the complainant's OPRA request seeking certain personnel information because all was disclosed. Dennis v. Garfield Board of Education, Bergen, GRC complaint number 2009-156, ed sec. Interim order dated April 28th, 2010. COO Esquire, OVO, AADARI v. Voorhees Police Department, Camden, GRC complaint number 2022-12, March of 2024. The custodian lawfully denied access to the portion of the complainant's OPRA request seeking any agreement because she certified, and the record reflects that no records exist. Pusterhofer v. NJ Department of Education, GRC complaint number 2005-49, July of 2005. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Reverend Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Deborah Tyler,
Yes.
Peter Michael v. Borough of Washington, Warren, 2022-27.
Student's failure to respond immediately to OPRA request item number 8 resulted in a violation of OPRA. NJSA 47:1A-5E, Heron v. Township of Montclair, GRC complaint number 2006-178, February of 2007. The complainant's failure to timely respond within the extended deadline resulted in a deemed denial of access. 47:1A-5G and 5I, as well as Cone, GRC 2007-124. The custodian lawfully denied access to complainant's OPRA request item numbers 1, 2, 5, except for the subject OPRA request, 6, and 7, because she certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. The GRC must conduct an in-camera review of 2 emails and relevant attachments to determine the validity of the custodian's assertion that same were lawfully denied under the attorney-client privilege exemption, NJSA 47:1A-1.1, PFE New Jersey Department of Labor Board of Review 379, NJ Super 346, Aptiv 2005. The knowing and willful analysis is deferred.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Reverend Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Deborah Tyler,
Yes.
Orlando Termini v. Randolph Township School District, Morris, 2022-37.
Lawfully denied access to the requested calendar proposals under the ACD exemption because they were in draft form, 47:1A-1.1 and 6, as well as Libertarians for Transparent Government, the Government Records Council, 453 NJ Super 83, Aptiv 2018.
Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Reverend Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Deborah Tyler,
Yes.
Rachel Lee Edelman, Esquire, on behalf of Bound Brook Education Association v. Borough of Bound Brook, Somerset, 2022-38.
Student's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. The custodian's February 25th, 2022 response was insufficient because she failed to address each OPRA request item individually. NJSA 47:1A-5 and PATH GRC 2007-272. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Reverend Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Deborah Tyler,
Yes.
Rotimi Oo, Esquire, on behalf of African American Data and Research Institute v. Raritan Police Department, Hunterdon, 2022-48.
Custodian's response was insufficient because she failed to address each OPRA request item individually. 47:1A-5G, PATH GRC 2007-272. The custodian did not unlawfully deny access to the portion of the complainant's Oprah request seeking certain personnel information because all was disclosed. Danis, GRC 2009-156, C. Voorhees, GRC 2022-12. Custodian lawfully denied access to the portion of the complainant's Oprah request seeking any agreement because she certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Reverend Brett Zabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ratati,
Yes.
Douglas Harrell v. New Milford Board of Education, Bergen, 2022-161.
Custodian lawfully denied access to the complainant's Oprah request item number 1 because she certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. The custodian lawfully denied access to the complainant's Oprah request number 2 under the personnel exemption, NJSA 47:18-10. Noche v. Township of West Milford, Passaic, GRC complaint number 2008-283, November of 2009. Portion of the complaint related to the complainant's Oprah request item number 3 is without merit and should be dismissed because he did not request the record identified therein, 47:18-6 and 7E, as well as Burns v. New Jersey Department of State, Division of Elections, GRC complaint number 2013-64, September of 2013.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Reverend Brett Zabaki,
Yes.
Michael Hahn,
He's
I
frozen.
think,
Frozen, yeah.
yeah, I think his computer went. Yep, there he goes.
Okay, 1 minute please until Mr. Hahn is able to rejoin.
Mm,
Do you want to try and get him on the cell phone and have him participate that way?
I'm sure he'll come back. As soon as with these screens of death, you have to do a hard restart and wait for everything to run back up. The last time he was back within a minute.
Okay.
Sort of an unusual circumstance. We've had plenty of technological situations since we started doing this on Teams 3 years ago, but this is actually a new one. Sure, the suspense is killing all of our public attendees, waiting to determine what the vote's going to be.
Well, we apologize.
Well, we do have a quorum to continue the vote, so instead of holding everybody up, I guess it would just be possible to record a no vote.
I wouldn't put a no, I would put abstain.
Or an abstained vote because he was
Yeah.
not here.
Correct.
Either way.
Yeah. Because he'll probably rejoin. I'm sure he'll. And here he
Yep.
is.
Here he is.
Okay.
And there
Okay.
he is.
Mr. Hahn,
Okay.
could you please vote on Douglas Harrell v. New Milford Board of Education, Bergen, 2022-161?
And you're on mute, Mike.
Yes.
okay.
Thank you.
John Alexi,
Yes.
Stephen Ratati,
Yes.
Douglas Harrell v. New Milford Board of Education, Bergen, 2022-173.
Clayton's complaint is without merit and should be dismissed because he did not request the records identified therein, 47:1A-6, as well as 7E, and Burns, GRC 2013-64.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Robin Beck-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ritadi,
Yes.
Robert Walden v. North Bergen Board of Education, Hudson, 2022-294.
Clayton's failure to respond immediately to the Oprah request resulted in a violation of Oprah, NJSA 47:1A-5E, and Heron, GRC 2006-178. Custodian unlawfully denied access to the requested invoices, canceled checks, and lease agreements responsive to the complainant's Oprah request, NJSA 47:1A-6. Thus, the custodian shall locate and disclose the records to the complainant or send the complainant legal certification if any do not exist.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Robin Beck-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ritadi,
Yes.
Maurice Bronson v. Township of Irvington, Essex, 2022-556.
Custodian unlawfully denied access to the complainant's Oprah request on the basis that no records existed. Welnick v. New Jersey State Police, GRC complaint number 2017-134, interim order dated February 26, 2019. Thus, the custodian shall disclose to the complainant the responsive record with redactions where applicable. O'Shea, GRC 2008-283.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Robin Beck-Tabaki,
Yes.
Michael Hahn,
Here we go again.
All right, so we can probably push. There you go.
Okay,
I switched
Not
to my
enough.
phone.
okay. Michael
Okay.
Hahn,
Yes.
John Alexi,
Yes.
Stephen Ritadi,
Yes.
Saul Jaffe v. City of Passaic, 2022-560.
Custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. The custodian lawfully denied access to the complainant's Oprah request because she's certified and the records reflect that no records exist. Boosterhopper, GRC 2005-49.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Robin Beck-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ritadi,
Yes.
Linda Kent v. City of Estelle Manor, Atlantic, 2022-629, consolidated with 2022-630.
Custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. However, the GRC declines to order any further action because the records responsive were disclosed to the complainant on December 29, 2022 and April 12, 2023, respectively. There is no knowing and willful violation. However, the custodian of Mr. Moore's actions were negligent and heedless.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second?
Robin Beck-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ritadi,
Yes.
Kevin Alexander v. New Jersey Department of Corrections, 2022-645.
Custodian did not violate Oprah when assessing the proper copy cost for hard copy disclosure of a record responsive to Oprah request item number 1, NJSA 47:1A-5B. Further, the custodian was not required to waive the fee. Reed v. GRC and NJ Department of Corrections, 2013, NJ Super Unpub, Lexus, 2625, at 5, Aptiv, 2013. Thus, the custodian is not required to disclose the record until receipt of the associated costs. Path v. City of Plainfield, GRC complaint number 2006-54, July of 2006. The custodian lawfully denied access to the complainant's Oprah request item number 2 because he certified, and the record reflects that no records exist. Hoosterhofer, GRC 2005-49.
Is there any discussion? Hearing none, motion please.
So moved.
Second?
Robert Brett Watkins,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Rivers Tidy.
Yes.
All right, that concludes the individual complaint adjudications. Thank you very much to everyone. We now move into court decisions of GRC complaints on appeal. Cawthon v. New Jersey Department of Corrections, 2024, NJ Super Unpub Lexus 506, Aptiv 2024.
Okay, the plaintiff, an incarcerated individual, requested logbooks regarding visits by his attorney under Oprah. The GRC held that because the records sought by the plaintiff were expressly exempt from disclosure pursuant to the defendant's regulations, access was properly denied. The appellate division affirmed the GRC, adding that the fact that the plaintiff could obtain the requested records through other avenues does not mean the request was improperly denied under Oprah.
Thank you. And now we move into complaints adjudicated in New Jersey Superior Court and New Jersey Supreme Court. Williams v. Mercer County Board of Elections, 2024, NJ Super Unpub Lexus 568, Aptiv 2024.
The plaintiff requested audio and visual recordings of a board meeting, claiming that a board member recorded the meeting with their smartphone. The board denied the Oprah request, stating that no responsive records exist. The appellate division found that the board provided a certification from the aforementioned board members, stating that while they tried to record the meeting, they were unable to get it to work. The court also held that the board meeting did not have a statutory obligation to record its meetings beyond providing written minutes. The court thus held there was no denial of access and denied the plaintiff's additional requests for attorney's fees and civil penalties. Affirmed.
Thank you. Benigno v. New Jersey Office of the State Comptroller, 2024, New Jersey Super Unpub Lexus 637, Aptiv 2024.
The plaintiff requested subpoenas, correspondence, and other records from the defendant pertaining to an investigation into the plaintiff's organization. The defendant denied access under Oprah's ongoing investigation exemption, and that the request was overly broad. The trial court agreed with the defendant. On appeal, the appellate division found that the request met the requisite prongs to be protected under Oprah's ongoing investigation exemption. The court also held that the entirety of the plaintiff's request was overly broad, as it sought records encompassing the entire scope of the defendant's investigation into the plaintiff's organization. Affirmed.
Thank you. African American Data and Research Institute, AADARI, LLC v. Hitchner, 2024, NJ Super Unpub Lexus 597, Aptiv 2024.
This matter is a consolidation of 3 trial court orders pertaining to Oprah requests submitted in 2022 by Rotimi Owo Esquire, purportedly on behalf of Adari. The appellate division initially found that Adari had 2 members, Mr. Owo's mother and adult son. The court also found that Mr. Owo's mother passed away sometime prior to 2020, and his adult son was described by Mr. Owo in other litigation as being mentally incompetent. The court found that Mr. Owo personally verified each of the complaints at issue and could not certify who at Adari directed him to submit the Oprah request at issue on its behalf. The court therefore held that Owo could not personally verify the complaints and act as Adari's counsel at the same time, nor could Mr. Owo demonstrate that he is either a member of Adari or that a member of Adari directed him to submit the Oprah requests. The court thus reversed and remanded to the trial court to dismiss the complaints with prejudice.
Thank you. ACLU of NJ v. County Prosecutors Association of NJ, 2024, NJ Lexus 365, 2024.
Plaintiffs argue that the defendant organization is an instrumentality of the state's county prosecutors and therefore subject to Oprah. The court initially found that county prosecutors are distinct from their respective counties because they are constitutional officers who serve by virtue of gubernatorial nomination and Senate confirmation. The court therefore found that county prosecutors themselves are not political subdivisions of the state, nor are they part of the county, which is a political subdivision. The court further found that the defendant is not an alter ego of the county prosecutors, as membership is not mandatory, has no statutory or constitutional powers, and has no law enforcement authority. The court thus held that the defendant is not a public agency within the meaning of Oprah and affirmed the appellate division's dismissal of the complaint.
Thank you. All right, we are now Well, all right, there are no complaints adjudicated in U.S. District Court, so we move into public comment. The public comment period is limited to providing an opportunity for speakers to present suggestions, views, and comments relevant to the council's functions and responsibilities. In the interest of time, speakers will be limited to 5 minutes. Speakers shall not be permitted to make oral or written testimony regarding pending or scheduled adjudications.
So for
Mr.
our
Crusoe.
our attendees here today, if anybody would like to make a public comment at this time, you can unmute yourself by pressing *6 on your telephone. *6 will unmute you, and we'll just need your name, and then you can give your public comment to the council if you so choose. As always, I'll give usually about 30 seconds or a little bit more for folks who are in attendance today to determine whether or not they're interested in giving public comment. So *6 is how you would unmute yourself if you would like to give public comment at this time. Okay. Give it about another 30 seconds if anybody's interested, another 15 seconds. If anybody's interested in giving public comment, *6 would be the way to go about that. Got another 10 seconds. Last call for public comments. *6 going in 3, 2. All right, Chairwoman, it looks like we have no takers today for public comment.
All right, thank you very much. I will now entertain a motion to adjourn. Mr. Retardi, you are on mute.
So moved.
Thank you.
Robin.
And seconded.
Robin Brett-Tabaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Retardi.
Yes.
All right, thank you very much. We are adjourned. We will see everyone next month. Appreciate your time.
Thank you all very much. Thank you for our attendees who attended today, as well as our council and our staff. Always appreciate it. And it's a quick turnaround. Don't forget, because of the Memorial Day holiday, we're a week earlier for our May meeting. So be on the lookout soon.
Thank you very, very much. Good afternoon, everyone.
Thanks for hanging in, Robin. Feel better.
Thank
Feel
you.
better, Robin. Michael, thanks for the entertainment.
Thank you.
Take care.
It's been a thing with this computer.
All right. Take care, guys.
Bye-bye.